Welcome to our channel, Cat Ventures NG Law, Obata Chambers. I am your usual host, John Choka Obata, attorney, and with me is my senior partner, Paul Machuku Obata. We are planning and environmental lawyers and property consultants. In this episode, we shall be dwelling on environmental litigation, application of common law doctrines. Make sure you subscribe to our channel, like our videos, share them, hit the notification button so you do not miss any planning and environmental law related videos from us. Also, use the comment section.
In environmental litigation, you see that negligence, in order to succeed, must prove the following principles. One, the polluter owed him a duty of care, and the polluter is in a breach of that duty of care, and then that breach has caused foreseeable damage to the plaintiff, where the plaintiff is able to prove this successfully. He succeeds, yes, indeed, in his case. There is also the provision for the rule in Ryland versus Fletcher. You see, rule in Ryland versus Fletcher was one of the cases that was imported into Nigerian legislation. You see, from the English law. And then the decision in this case of rule in Ryland versus Fletcher established strict liability tort. Strict liability tort. And the principle says that polluter is liable irrespective of wrongful intent of negligence. The rule of law is that the person who brings on his land, collects, and keeps there anything likely to do mischief, if it escapes, it is prima facie answerable for all the damage which is the natural consequences of the escape. You see, for the plaintiff to be successful in the application of the doctrine of the rule in Ryland versus Fletcher, for the plaintiff to succeed, relying on this principle as decided by the House of Lords, he must prove that, one, that there was a non-natural use of land by defendant. Two, he must show that there was an escape of the material or object from the defendant's adjoining land to his property. And the rule has no doubt been successful. So successfully applied in environmental law cases and litigation, most particularly those involving the oil and gas sector, the oil and gas industry. In this regard, the apex court, that is Supreme Court, had no difficulty in affirming the defendant's due and necessary liability under the rule in Ryland versus Fletcher, especially where there was escape of oil from oil field into the plaintiff's pond, into the plaintiff's farmland, into the plaintiff's lake, or other sources of drinking water, causing damage. Here, the rule in Ryland versus Fletcher applies. Or it could be that of a keeper of an animal, and the animal escapes into another man's land, into another man's property, to cause harm, physical harm. You see, all these are actionable causes of action. I mean, they are causes of action. And the rule in Ryland versus Fletcher also applies here. Then, there is another doctrine which can also apply. That is the res ipsa loquitur doctrine. Res ipsa loquitur. You see, res ipsa loquitur means the thing speaks for itself. The effect of the application of the doctrine of res ipsa loquitur is that the onus of proof of negligence, which lies on the plaintiff by the rules of evidence, has merely shifted. It merely shifts to the defendant by the application of res ipsa loquitur. And so the defendant is there required to establish that there was, in fact, no negligence or want of care on his part to succeed. So it is an appropriate circumstantial evidence enabling the plaintiff in particular to establish the defendant's likely negligence, as in the case of Shell versus Amaro. Shell versus Amaro, look for it. As a law student, these cases are very, very helpful to you if you are if environmental law or planning and environmental law is one of your courses. You see? So negligence arises from lack of proper care and attention, careless behavior or conduct. And that is why the law is there, to keep a check on careless behavior, to make the behavior of the citizenry predictable. So, in this particular instance of negligence, there is a duty of care. And that duty of care has been breached. And so the plaintiff suffered damages arising from the breach. You see, in the case of the animal that I mentioned earlier, the rule also applies that the animal does that at his owner's risk. The damage caused by the animal when it escapes into another man's land to do harm or to cause damage, to destroy. That rule is that, and that animal does that at his own risk. He owns a duty of care to his neighbor for any injury caused by that animal's behavior. See Derian versus Njoku, 1965. Derian versus Njoku, 1965. So, the liability of the keeper of the animal is strict. The liability of the keeper of animal is strict. Although there are defenses. The defenses to the rule in Ryland versus Fletcher, if the defendant is able to prove beyond reasonable doubt that the defenses could be one, that it was an act of God, two, that the fault, it was the fault of the plaintiff. If you could prove that it was the fault of the plaintiff, if you could also prove that it was a contributory negligence. There was a contributory negligence. Or it was an act of stranger or third party other than himself. If he's able to prove that it was the act of a statutory authority, etc. You see, the proof of any of the above acts and exceptions defeats any claim for liability and damages. Yes. That is, it is pertinent that you understand the place of standing in environmental matters or in environmental cases. That is the issue of locus standi. Locus standi, the place of standing in an environmental matter. You see, the right to bring an action or to be heard in court is in a given form, and it is most fundamental principle of virtually all jurisprudence and environmental litigation that a party who commences an action must have locus standi to do so. The plaintiff must show sufficient interest in the matter. Remember, I have been mentioning proprietary interest, and that interest must be sufficient in the matter. Yes, this is one understanding that a person bringing an action must put in mind. You must have this in mind. You must be sure you have sufficient interest in the matter. Then, as a plaintiff, and the defendant has not been able to prove using any of the defenses, you see, then the following remedies are available to him. The following remedies are available to the claimant. One, that is damages and injunctions, which may be mandatory or prohibitive. You see, so the remedy for a private nuisance is either by abatement or by an action for damages, or action for injunction, or for mandamus. I will explain this. There are judicial remedies that apply, and these judicial remedies could be the writ of prohibitions. You see, and it could be the writ of mandamus, or it could be the writ of injunctions. In the case of the writ of injunctions, that is, the court could place a restraining order. Yes, could place a restraining order on the defendant. You see, and then there could also be the writ. You can also be following another action that you may take other than the writ of injunctions. You could take the writ of mandamus. That is, you may be pressing for a specific performance. We'll be going into detail into all these aspects, you know. Yes, for a specific performance, you know, you may be pressing for a specific performance. And then the remedy, which it could be a remedy that is available to you. It could also be the writ of prohibitions. That is, there is an order also that prohibits that particular action. There could be given an order that prohibits that action. You see, and then there could be other declarations as well. You see, so mandamus can apply where the consent of the Attorney General is obtained, or where the Attorney General is not part of the case. So citizens have the right to press for specific performance. Yes, you have the right to press for specific performance. So we shall be going into other aspects like industrial pollution control and some other aspects of the environment where this applies. So please don't forget to subscribe to our channel and also hit the notification button so that you don't miss any of our videos. We'll get them across to you as it comes. And then also to reach you with our bi-monthly environmental newsletter. We have the Green Facts and Homes, product of CADventures NG Law. You see, we the Opata Chambers, we are known for that very, very useful and informative Green Facts and Homes newsletter. Yes, by hitting the notification button and also by subscribing to our channel, you can even reach us by DM us, and then we will be making it available to you whenever it comes out. You get a copy of